Chapter 2, Part 2 of California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis by Walter W. Heiser, published by LexisNexis, 2007-2008 edition. This is Subpart B of Chapter 2, after reading Statutes of Limitations, that shifts into attorney's fees. California follows the so-called American rule with respect to the recovery of attorney fees, which, in the absence of an established exception, requires each party to bear its own attorney fees. See Serrano v. Unruh of 1982, Alaska Pipeline Co. v. Wilderness Society of 1975. California does recognize many exceptions based on fee-shifting statutes, judge-made equitable doctrines, and contractual provisions. Not only does the legislature authorize parties to allocate attorneys' fees by agreement, CCP 1021, it also makes an otherwise unilateral contractual right to recover attorneys' fees reciprocally binding upon all parties in an action to enforce the contract. See Civil Code 1717. If they write that in their contract, it'll be honored. The legislature has enacted numerous fee-shifting statutes which authorize courts to award reasonable attorney's fees to the prevailing party. CCP 1021.5, Private Attorney General Statute, and CCP 1028.5, Actions between Small Business and State Regulatory Agency. Government Code Section 6259D, Public Records Act, Government Code Section 12965B, Fair Employment and Housing Act, now the CRD, and Civil Code Section 1811.1, Retail Installment Sales Act. This is all very familiar to me. The U.S. Congress has also enacted similar or numerous fee-shifting statutes which may apply when a party seeks enforcement of the federal statute in state court. See Socolow v. County of San Mateo in 1989. Superior Court directed to award attorney's fees under both Title 42 of the United States Code Section 1988 and CCP 1021.5 in Civil Rights Action. Green v. Oblito in 1984, Superior Court. The holding was a Superior Court must apply federal fee-shifting statute when federal claim brought in state court. These statutory and contractual bases for recovery of attorney's fees constitute very significant departures from the American rule. In addition, although perhaps less significant in overall impact, the California courts have created several exceptions to the American rule based on equitable theories. These include the common fund, substantial benefit, private attorney general, and third-party tort doctrines. See Serrano v. Priest, 1977, and Prentice v. North American Title Guarantee Corp. in 1963. Consideration of these judge-made exceptions still does not provide a complete picture of attorney fee recovery in California. In appropriate situations, a court may award attorney fees as a sanction for bad faith litigation, CCP Section 128.7, for misuse of the discovery process, CCP 2023, and for frivolous appeals from CCP 907, Rule 8.276 of the California Rules of Court. Graham v. Daimler Chrysler Corp., heard by the Supreme Court of California in 2004. Opinion given by Justice Moreno reads as follows. In this case, defendant offered to repurchase a truck that had been marketed with false statements about its towing capacity. This offer came after a lawsuit plaintiffs filed against defendant seeking this repurchase remedy. But before any kind of court judgment was rendered, plaintiffs were awarded substantial attorney's fees under CCP 1021.5. Defendant raises several issues regarding those fees. The first is whether we should reconsider the catalyst theory recognized by this court in Westside Community for Independent Living, Inc. v. Oblito, 1983. Under the catalyst theory, attorney's fees may be awarded even when litigation does not result in a judicial resolution of the defendant changes its behavior substantially because of and in the manner sought by the litigation. We conclude the catalyst theory should not be abolished but clarified. In order to be eligible for attorney fees under Section 1021.5, a plaintiff must not only be a catalyst to defendant's change behavior, but the lawsuit must have some merit as discussed below, and the plaintiff must have engaged in a reasonable attempt to settle its dispute with the defendant prior to litigation. Because these limitations on the catalyst theory are to some degree new and were not addressed by the parties or the trial court, we remand for consideration of the trial court's award of attorney's fees in this case. I'm going to skim the rest of the case because that really sounds like the holding, the conclusion, the takeaway. But there was another issue that the defendants contended at trial court the trial court erred in concluding that the present lawsuit substantially benefited a large group of people or the general public as required by 1021.5. We conclude the trial court did not abuse its discretion in making that conclusion. Finally, a defendant, while conceding that a plaintiff could be awarded attorney's fees for attorney fee litigation, contends that these facts should not be enhanced beyond the lodestar amount. We do not endorse such a categorical rule, but we explain below that fees for fee litigation usually should be enhanced at a significantly lower rate than fees for the underlying litigation, if they are enhanced at all. We therefore will remand the cause to the trial court to recalculate the amount of the fee in light of the principles discussed below, assuming it finds on remand that plaintiffs are eligible for some attorney's fees. So that second issue has to do basically with the notoriety of the decision and whether that comes into the calculus for the catalyst theory. But then there's also the lodestar principle that I could use a reminder on. So the statement of facts here, the facts taken largely from the Court of Appeals opinion are as follows. Daimler Chrysler incorrectly marketed its 1998-1999 Dakota RT trucks as having a 6,400 pound towing capacity when they could actually tow only 2,000 pounds. The error occurred because the Dakota RT was a sporty version of the existing truck model which could tow 6,400 pounds. However, to obtain a sporty design, Daimler Chrysler lowered the suspension on the Dakota RT, thus reducing its towing capacity. The reduced towing capacity was a potential risk factor. The lower suspension meant that towing more than 2,000 pounds could cause the suspension to bottom out, stressing the frame and increasing fatigue and wear. The Daimler Chrysler response team considered this a potential safety issue. Buyers who wanted to tow more than 2,000 pounds were told they could do so only if their Dakota RT was modified with a trailer hitch costing $300. The factory installed some of these hitches, while other buyers who wanted to tow had dealer installed or aftermarket hitches attached. Nationwide, Daimler Chrysler sold or leased fewer than 7,000 of the Dakota RTs in the two relevant years. Fewer than 1,000 affected RTs were sold in California during the 2 years. By February 1999, Daimler Chrysler set up a response team to address the problem. By June of 1999, Daimler Chrysler had taken steps to replace the incorrect marketing materials, owner manuals, and engine and door labels for not yet sold Dakota RTs, although public agency investigation revealed that brochures misrepresenting the truck's towing capacity were still being distributed as of August 1999. Daimler Chrysler also had notified existing buyers of the error, told them not to attempt to tow more than 2,000 pounds, and provided them with the same modified materials. Simultaneously, Daimler Chrysler began to address remedial issues for customers who had bought or leased Dakota RTs under the incorrect marketing program. Many Dakota RT buyers never intended to tow more than 2,000 pounds. When informed by Daimler Chrysler of the error, most of these customers were satisfied with Daimler Chrysler's offers and of cash and merchandise. Initially, Daimler Chrysler did what? Offered $300 refunds to buyers who had purchased hitches of that amount. By the summer, Daimler Chrysler authorized dealers to repurchase or replace Dakota RTs on a case-by-case basis, but only for customers who demanded such a remedy. On July 29, 1999, the Santa Cruz County District Attorney contacted Daimler Chrysler about the problem, threatened legal action, and requested Daimler Chrysler's input before acting. On August 10, 1999, the California Attorney General notified Daimler Chrysler it had joined the Santa Cruz County District Attorney. The public agencies requested a response by the end of August 1999. Plaintiffs filed their case on August 23, 1999 in Los Angeles County Superior Court. Plaintiffs alleged they all bought 1999 Dakota RTs from various Daimler Chrysler dealers. Only Graham lived and bought his truck in California. Plaintiffs alleged Daimler Chrysler marketed, sold, and warranted their 1998 and 1999 Dakota RTs as capable of towing 6,400 pounds when the trucks actually could tow only 2,000 pounds. Plaintiff alleged Daimler Chrysler acknowledged the error by letter to all purchasers dated June 16, 1999. Plaintiffs alleged they notified Daimler Chrysler of their truck's failure to comply with the warranted towing capacity, and 2, revocation of their acceptance of their trucks on July 19, 1999. Plaintiffs sought but never obtained class certification for all those who bought Dakota RTs nationwide. Plaintiffs alleged a single breach of express warranty cause of action. Plaintiffs sought return of their purchase or lease payments, compensatory damages, and attorney's fees. Also on August 23, 1999, the Detroit News contacted Daimler Chrysler's legal counsel about plaintiff's case. Daimler Chrysler's counsel claimed Daimler Chrysler had responded appropriately to the marketing error, including offering buybacks to customers who requested it. Plaintiffs faxed their complaint to Daimler Chrysler the same day. The next day, August 24, 1999, Daimler Chrysler's employee newsletter ran an article on plaintiff's case. Daimler Chrysler response team met through August 1999. The team knew about both public agency inquiries and the response deadline. Indeed, Daimler Chrysler wrote the public agencies that its internal approval process prohibited a response by August 31, but promised a response by September 8, 1999. On September 10, 1999, Daimler Chrysler issued its offer to all previous Dakota RT buyers to repurchase or replace. In response to later inquiries, response team members conceded that they were aware of the class action lawsuit filed in California before Daimler Chrysler's September 10, 1999 letter offering repurchase or replacement to all Dakota RT buyers. Daimler Chrysler demurred to the complaint. Plaintiffs filed an amended complaint acknowledging Daimler Chrysler's offer of, among other remedies, repurchase or replacement of the trucks for all previous buyers. The trial court sustained the demur without leave to amend and dismissed the case, finding it was moot because Daimler Chrysler already had offered all purchasers the relief plaintiffs sought. Meanwhile, the public agencies continued to pursue legal action against Daimler Chrysler, pointing to the fact that the erroneous marketing of the Dakota RT continued as late as September 1999. In late 2000, Daimler Chrysler settled the public agency investigations by paying a $75,000 fine and agreeing to ensure that the marketing error did not recur. Nationwide, 2,459 Dakota RT buyers opted for repurchase or replacement. Another 3,101 buyers opted for service contracts and parts coupons. The total value of these cash offers exceeded $15 million. Fewer than 1,000 of the RT buyers were Californians. Although plaintiff's case was dismissed, the parties continued to litigate plaintiff's entitlement to attorney's fees. Daimler Chrysler insisted throughout that plaintiffs were not entitled to attorney's fees, contending plaintiffs had no effect on Daimler Chrysler's recognition of the problem and decision to offer all buyers repurchase or replacement. For over a year, there were hotly contested discovery and other motions to clarify the facts described above. The court held a lengthy evidentiary hearing on October 18, 2000. Daimler-Chrysler contended that the Dakota RT response team was not even aware of the litigation until after September 10, 1999, when its repurchase offer was made, a position the trial court found to lack credibility. The trial court filed its final order awarding attorney's fees on July 6, 2001. The court concluded after its review of the declarations and documentary evidence presented that Daimler-Chrysler's position that the lawsuit was not a catalyst was largely a transparent fabrication. It rejected Daimler-Chrysler's argument that plaintiff's action was unnecessary because of the enforcement action of the Santa Cruz County District Attorney and the California Attorney General. The trial court found that these agencies had only made an inquiry and had not commenced any proceedings when plaintiffs filed this action. Further, those agencies were only concerned with Daimler-Chrysler's false advertising materials and never sought any remedies on behalf of consumers who acquired these vehicles while they were being misrepresented. In addition to finding the plaintiffs were the successful party, the trial court found the other requirements of Section 1021.5 had been met. It found the lawsuit resulted in the enforcement of an important right affecting the public interest, the protection and enforcement of consumer rights, including highway safety, and that, as a result of the lawsuit, thousands of consumers received pecuniary benefits and enhanced safety. Thousands more are likely to benefit from it if Daimler-Chrysler and or other manufacturers were deterred from similar conduct in the future. The court also concluded that Daimler-Chrysler should pay plaintiffs' attorney's fees in the interest of justice. Plaintiffs' attorney's fees will otherwise go unpaid. Fees cannot be paid out of benefits conferred upon consumers because Daimler-Chrysler distributed the benefits of its offer to the consumers without any discussion with plaintiffs or their attorneys. Justice is served by encouraging lawyers to bring meritorious consumer cases, of which this action is an example. Trial court found the lodestar fee amount of $329,620 through the October 18, 2000 hearing, with a multiplier of 2.25 for the fees incurred until the October 18, 2000 hearing, including fees for litigating attorney's fees, and applied no multiplier for time thereafter. The court awarded no fees for work after April 23, 2001. The total award was $762,830,000. The Court of Appeal affirmed. It observed that the United States Supreme Court had recently rejected the catalyst theory as a basis for attorney fee awards under various federal statutes in Buchanan Board and Home Care, Inc. v. West Virginia Department of Health and Human Services of 2001. But the court declined to follow the United States Supreme Court's lead, noting that the catalyst theory has been long recognized in California. The court also rejected arguments that the litigation was not in the public interest and that it did not benefit a substantial number of people. Further, the court concluded that the trial court did not abuse its discretion in awarding fees for seeking fees and in permitting those fees to be enhanced over the basic lodestar amount. We granted review. Discussion. I already see a couple flaws going on here, but the discussion reads, A, whether the catalyst theory should be abolished. An important exception to the American rule that litigants are to bear their own attorney's fees is found in 1021.5 as we have stated. The legislature adopted Section 1021.5 as the codification of the private attorney general doctrine of attorney's fees developed in prior judicial decisions. Under this section, a court may award attorney's fees to a successful party in any action that has resulted in the enforcement of an important right affecting the public interest if A, a significant benefit, whether pecuniary or non-pecuniary, has been conferred on the general public or a large class of persons. B, the necessity of financial burden of private enforcement are such as to make the award appropriate. And C, such fees should not be in the interest of justice. Should not in the interest of justice be paid out of the recovery, if any. The private attorney general doctrine rests upon the recognition that privately initiated, just kind of book briefing right now. Okay, so this rule actually involves the private attorney general doctrine of attorney's fees. It doesn't. It's not the catalyst theory, but those might be interchangeable. So I just read the elements. A significant benefit, whether pecuniary or non-pecuniary, has been conferred on the general public or a large class of persons. The necessity and financial burden of the private enforcement are such as to make the award appropriate, and C, such fees should not, in the interest of justice, be paid out of the recovery, if any. Now, the next part, the private attorney general doctrine, rests upon the recognition that privately initiated lawsuits are often essential to the effectuation of the fundamental public policies embodied in constitutional or statutory provisions, and that without some mechanism authorizing the award of attorney's fees, private actions to enforce such important policies will, as a practical matter, frequently be infeasible. Thus, a fundamental objective of the doctrine is to encourage suits enforcing important public policies by providing substantial attorney's fees to successful litigants in such cases. Now, these are California rules, and I'm just curious because the class action was filed in the LA, but I don't know if it was under the federal rules or the California rules for class actions, and I feel that that's relevant here. According to the Erie Doctrine, what rules apply, what procedural rules apply, as to, say, for instance, the attorney's fees. But I guess I can see why it would be a question for the court. But that's one question I'm seeing here to highlight, and then to, factually, was the class action actually the catalyst, is another good question. In order to effectuate that policy, we have taken a broad, pragmatic view of what constitutes a successful party. Our prior cases uniformly explain that an attorney fee award may be adjusted even when plaintiff's legal action does not result in a favorable final judgment. Westside Community Supra and Press vs. Lucky Source Inc. of 1983. Although their action had become moot in those two cases, or at least in Press vs. Lucky Star, plaintiffs were awarded fees under 1021.5 because they had achieved the relief they sought through a preliminary injunction. The trial court, in its discretion, must realistically assess the litigation and determine from a practical perspective whether or not the action served to vindicate an important right so as to justify an attorney fee award under Section 1021.5. The catalyst theory is an application of the above stated principle that courts look to the practical impacts of the public interest litigation in order to determine whether the party was successful and therefore potentially eligible for attorney's fees. We specifically endorse that theory in Westside Community. The Westside Community Court, although endorsing the catalyst theory, nonetheless went on to conclude that no attorney's fees were owed in that case because there was no demonstrable causal connection between the lawsuit and the government's action. We continue to conclude that the catalyst theory in concept is sound. The principle upon which the theory is based, that we look to the impact of the action, not its matter of resolution. Folsom Supra is the quote for that, is fully consistent with the, in-text citation, is fully consistent with the purpose of Section 1021.5 to financially reward attorneys who successfully prosecute cases in the public interest and thereby prevent worthy claimants from being silenced or stifled because of the lack of legal resources. Again, In citation credit to Folsom, Supra, we therefore reaffirm our endorsement of the catalyst theory. Daimler Chrysler argues that we should reevaluate that endorsement in light of the rejection of the catalyst theory by the United States Supreme Court in Buchanan. At the outset, we state that hardly needs stating. The U.S. Supreme Court interpretation of federal statutes does not bind us to similarly interpret similar state statutes. Indeed, in the realm of attorney's fees for private attorneys general, this court has markedly diverged from the United States Supreme Court precedent. In Serrano v. Priest, Serrano 3, an opinion that predated the effective date of Section 1021.5, Serrano v. Unruh, Serrano 4, this court rejected the holding of Alaska Pipeline, I thought it was Alaska, of 1975, that attorney's fees cannot be awarded on a private attorney general theory absent express statutory authorization from Serrano 3. More recently, we unanimously declined to follow the United States Supreme Court rejection of the use of the contingency fee multiplier in calculating private attorney's fees. See Ketchum v. Moses in no date. 2001. We reaffirmed that the fashioning of equitable exceptions to the California rule that parties must bear their own costs is a matter within the sole competence of this court. As explained below, we do not find the reasoning of the 5-4 majority in Buchanan persuasive and decline to apply its holding to Section 1021.5. A good deal of the Buchanan court's reason for rejecting the catalyst theory turns on the definition of prevailing party. The Buchanan majority found the term prevailing party to be a legal term of art defined according to Black's Law Dictionary as a party in whose favor a judgment is rendered regardless of the amount of damages awarded. In certain cases, the court will award attorney's fees to a prevailing party, also termed successful party. This definition, together with prior court decisions, led the Buchanan majority to conclude that a prevailing party must be a party that brought about a material alteration of the legal relationship of parties, which could include both a judgment on the merits and a settlement agreement enforced through a consent decree. The Buchanan majority concluded that the catalyst theory falls on the other side of the line from these examples. It allows an award where there is no judicially sanctioned change in the legal relationship of the parties. Even under a limited form of the catalyst theory, a plaintiff could recover attorney's fees if it established that the complaint had sufficient merit to withstand a motion to dismiss for lack of jurisdiction or failure to state a claim on which relief may be granted. This is not the type of legal merit that our prior decisions, based upon plain language and congressional intent, have found necessary. A defendant's voluntary change in conduct, although perhaps accomplishing what the plaintiff sought to achieve by the lawsuit, lacks the necessary judicial imprimatur on the change. Our proceedings thus counsel against holding that the term prevailing party authorizes an award of attorney's fees without a corresponding alteration in the legal relationship of the parties. We agree with still book briefing. The holding was at the very beginning, and there was some nice language. About, I called it notoriety of the case, but there's another holding. We conclude there are two holdings. This was issue 2. Okay. be kind of like their legislative intent. Okay, so where were we? Okay. We agree with Daimler Chrysler that the terms prevailing party and successful party as used in Section 1021 are synonymous. We also agree that in context of Section 1021.5, the term party refers to a party to litigation and therefore precludes an award of attorney's fees when no lawsuit has been filed. Party is a technical term having a precise meaning in legal parlance. It refers to those by or against whom a suit is brought. The party plaintiff refers to those by or against whom a suit is brought, the party plaintiff or defendant. But we are aware of no judicial construction or legislative usage in California that limits the terms prevailing party to or successful party to the meaning found in the most recent edition of Black's Law Dictionary, to the exclusion of other meanings, as Daimler Chrysler following the Buchanan majority argues. We therefore turn to the usual and ordinary meaning of a statutory language in order to discern legislative intent. The term successful party, as ordinarily understood, means the party to litigation that achieves its objectives. We agree with the dissenting opinion in Buchanan. In everyday use, prevail means gain victory by virtue of strength or superiority, win, mastery, triumph. According to Webster's, there are undoubtedly situations in which an individual's goal is to obtain approval of a judge, and in those situations one cannot prevail short of a judge's formal declaration. Giving an example here. And going then to the ultimate purpose is to achieve actual relief from an opponent. Favorable judgment may be instrumental in gaining that relief. Generally, however, the judicial decree is not the end but the means. At the end of the rainbow lies not a judgment but some action or a cessation of action by the defendant. On this common understanding, if a party reaches the sought-after destination, then the party prevails regardless of the route taken. Daimler Chrysler also makes a number of policy arguments like the Buchanan majority. It argues that a request for attorney's fees should not result in a second major litigation, and that the catalyst theory would require complex causal determination. Among other things, a catalyst theory hearing would require analysis of the defendant's subjective motivations in changing its conduct, an analysis that will likely depend on a highly fact-bound inquiry and may turn on reasonable inferences from the nature and timing of the defendant's change of conduct. We find persuasive the argument of the Buchanan dissent that although some time may be expended in fact-finding under the catalyst theory, it is at least as likely as not that the catalyst rule saves judicial resources by encouraging plaintiffs to discontinue litigation after receiving, through the defendant's acquiescence, the remedy initially sought. Nor are we persuaded that cases decided under catalyst theory will inevitably give rise to complex or time-consuming litigation over the issue of causality. Case law, as well as our own judicial experience, suggests that catalyst theory cases may be resolved by relatively economical, straightforward inquiries by trial court judges close to and familiar with the litigation. Moreover, the defendant in such cases knows better than anyone why it made the decision that granted the plaintiff the relief sought, and the defendant is in the best position to either concede that the plaintiff was a catalyst or to document why the plaintiff was not. We are unpersuaded that Daimler Chrysler's inability or unwillingness to do either in the present case, thereby prolonging the litigation, is necessarily attributable to the inherent difficulty of catalyst theory cases. Daimler Chrysler further argues that overall, the benefits that the catalyst rule is supposed to possess are dwarfed by the harms that the rule will engender. It contends the evil to which the catalyst rule is addressed that meritorious plaintiffs and plaintiffs' attorneys will be deprived of attorneys' fees by a favorable settlement will be a relatively rare occurrence. On the other hand, Dale McChrysler argues the catalyst rule could encourage nuisance suits by unscrupulous attorneys hoping to obtain fees without having the merits of their suit adjudicated. We, of course, have no way of quantifying the magnitude of the potential that actual abuses by plaintiffs under a catalyst rule or by defendants under its absence. Dale McChrysler and the Buchanan majority prediction that defendants' change of behavior depriving worthy plaintiffs of attorney's fees will be relatively rare is one we cannot verify. But as plaintiffs argue, what is objectionable about elimination of the catalyst theory is not only that in a given case an attorney will be unjustly deprived of fees, but that attorneys will be deterred from accepting public interest litigation. In the prospect, they will be deprived of such fees after successful litigation. C. Chemerinsky, Closing the Courthouse Doors to Civil Rights Litigants, a person who I met in person, a professor that I met in person. As matters stand now, public interest attorneys often take a considerable risk that they will not be paid at all because they will not prevail in the litigation or because they will be deemed ineligible for fees under Section 1021.5 as when the suit was adjudged not to be sufficiently in the public interest. Abolition of the catalyst theory will increase an already considerable risk, as plaintiff's attorney succinctly states. It defies common sense to think attorneys who take meritorious public interest cases with the expectation that they are to be compensated if they obtain favorable results for their clients will not be deterred from doing so if the defendant can litigate tenaciously, then avoid paying their fees by voluntarily providing relief before the court order is entered. Nor do we believe that avoiding this increased risk of public interest litigation must inevitably come at the expense of rewarding a significant number of extortionate lawsuits. We can adopt sensible limitations on the catalyst theory that discourage the latter without putting a damper on lawsuits that genuinely provide a public benefit. Our starting point in this endeavor is the observation that the legislature has assigned responsibility for awarding fees under Section 1021.5 not to automatons unable to recognize extortionists, but to judges expected and instructed to exercise discretion. Citing Buchanan. In the disposition opinion of Ginsburg. Interesting. All right, so a number of circuits in the United States Court of Appeals prior to Buchanan, I don't know, it's one thing that I agree with Ginsburg. Rare. On a rare occasion that happens. So, where were we? So, after Ginsburg's dissent opinion, a number of circuits in the United States Courts of Appeals prior to Buchanan adopted a version of the catalyst theory that required not only a causal connection between the lawsuit and the relief obtained, but also a determination that defendant's conduct was required by law. Generally speaking, the required by law prong was tantamount to a finding that the lawsuit was not frivolous, unreasonable, or groundless. This court has not explicitly adopted the above two-pronged test. We now do so. The trial court must determine that the lawsuit is not frivolous by threat of victory, not by dint of nuisance and threat of expense. The determination the trial court must make is not unlike the determination it makes when asked to issue a preliminary injunction. For example, not a final decision on the merits, but a determination at an amount that questions of law or fact are grave and difficult. So those are like standards for using court discretion. They compare it to an injunction. In addition to some scrutiny on the merits, we conclude that another limitation on the catalyst rule proposed by the Attorney General proposes that a plaintiff seeking attorney's fees under the catalyst theory must In addition to some scrutiny of the merits, we conclude that another limitation on the catalyst rule proposed by the Attorney General, appearing as amicus curiae, should be adopted by this court. The AG proposes that a plaintiff seeking attorney's fees under the catalyst theory must first reasonably attempt to settle the matter short of litigation. We believe this requirement is fully consistent with the basic objectives behind Section 1021.5 and with one of the explicit requirements, the necessity of private enforcement of the public interest, awarding attorney's fees for litigation when those rights could have been vindicated by reasonable efforts short of litigation does not advance the objective and encourages lawsuits that are more opportunistic than authentically for the public good. Lengthy pre-litigation negotiations are not required, nor is it necessary that the settlement demand be made by counsel, but a plaintiff must at least notify the defendant of its grievances and propose remedies and give the defendant the opportunity to meet the demands within the reasonable time. What constitutes a reasonable time will depend on the context. Applying the catalyst rule as discussed above to the present case, the trial court applied the first prong of the rule to conclude that the lawsuit was in fact a substantial causal factor in Daimler Chrysler's change in policy with respect to its willingness to repurchase or replace the Dakota RT or to offer consumers substantial discounts. Daimler Chrysler does not contend that the trial court's ruling on that point is unsupported by substantial evidence, but is unclear whether the trial court considered the merits of the suit, and the trial court did not consider whether plaintiffs attempted to reasonably settle the matter short of litigation. We therefore remand the matter for determination of whether plaintiffs are eligible for attorney's fees under the catalyst rule as articulated above. So that's the discussion of the first rule, issue, and there are two more issues and another discussion. Okay, and two more issues and a dissenting opinion. The reason I'm pausing is because it's getting really long for one recording, but it's due to case law. So let's just read the end of this opinion and then get into the dissent in the next recording. So issue 2, trial court did not abuse its discretion in finding the substantial benefit and public interest prongs of section 1021 were met. Daimler Chrysler also contends that the attorney fee award must be overturned in its entirety because it failed to confer a significant benefit on the general public or a large class of persons as required by section 1021.5. This contention need not detain us long. We will uphold the trial court's decision to award attorney's fees under 1021.5 unless the court has abused its discretion. From Hewlett v. Squaw Valley Ski Corp. 1997, it is well settled that attorney's fees under section 1021.5 may be awarded for consumer class action suits benefiting a large number of people. From Beasley v. Wells Fargo Bank, 1991, upholding which in that case upheld an award of section 1021 attorney's fees for class action against bank charging excess credit card fees. As Beasley recognizes, section 1021 requires both a finding of significant benefit conferred on a substantial number of people and the determination that the subject matter of the action implicated the public interest. In the present case, the trial court found that the problem addressed by the lawsuit implicated an issue of public safety and that the lawsuit benefited thousands of consumers and potentially thousands more by acting as a deterrent to discourage lax responses to known safety hazards. In light of the facts reviewed in the first part of the opinion, we conclude the trial court did not abuse its discretion in finding that the lawsuit met the substantial benefit and public interest requirements of section 1021.5. Subpart C of the discussion, probably issue 3, whether there should be a multiplier for attorney's fees for litigating attorney's fees. In the present case, a large percentage of the attorney's fees were awarded for litigation to obtain fees under 1021.5. As noted, the lodestar amount calculated by the trial court was $329,000, and the amount was multiplied by an enhancement of 2.25 for a total of $762,000. The trial court based the enhancement on the contingency nature of the litigation, the delay in payment of the quality of the result. Daimler Chrysler argues that there should be no enhancement for fees for fee-related litigation or fees on fees, assuming the trial court concludes on remand that plaintiffs are entitled to some attorney's fees. We address for its benefit whether to appropriately award enhancements for fees on fees. We conclude that while fees for attorney fee litigation under Section 1021.5 may be enhanced under some circumstances, that enhancement should generally be lower than fees awarded in the underlying litigation. We first review some general principles regarding the calculation of attorney's fees in public interest litigation. As we recently explained under our decision in Sereno, a court assessing attorney's fees begins with a touchstone or lodestar figure. In public interest litigation, as we recently explained under our decision Serrano 3, a court assessing attorney's fees begins with a touchstone or lodestar figure based on a careful compilation of time spent and reasonable hourly compensation of each attorney involved with the presentation of the case. Citation omitted. We expressly approved the use of prevailing hourly rates as a basis for the lodestar, noting that anchoring the calculation of attorney's fees to a lodestar adjustment method is the only way of approaching the problem that can claim objectivity, a claim which is obviously vital to the prestige of the bar and the courts. Citation omitted. In reference to reasonable compensation, we indicated that trial courts must carefully review attorney documentation of hours expended. Padding in the form of inefficient or duplicative efforts is not subject to compensation. Under Serrano 3, the lodestar is the basic fee for comparable legal services in the community. It may be adjusted by the court based on factors including 1, the novelty and difficulty of the questions involved, 2, the skill displayed in presenting them, 3, the extent to which the nature of the litigation precluded other employment by the attorneys, 4, the contingent nature of the fee awarded, and citation omitted. The purpose of such adjustment is to fix the fee at the fair market value for the particular action. In effect, the court determines retrospectively whether the litigation involved a contingent risk or required extraordinary legal skill, justifying augmentation of the unadorned lodestar in order to approximate the fair value rate for such services. The experienced trial judge is the best judge of the value of professional services rendered in his court, and while his judgment is of course subject to review, it will not be disturbed unless the appellate court is convinced that it clearly is wrong. In Ketchum, the earlier lodestar citations were omitted, and I wonder if lodestar case has been depublished. So, moving on the most common fee enhancers, and one used by the trial court in the present cases for contingency risk, we reaffirmed the propriety of the contingency risk enhancement in Ketchum. The economic rationale for the fee enhancement in contingency cases has been explained as follows. A contingent fee must be higher than a fee for the same legal services paid as they are performed. The contingent fee compensates the lawyer not only for the legal services he renders, but for the loan of those services. The implicit interest rate on such a loan is higher because the risk of default, the loss of the case, which cancels the debt of the client to the lawyer, is much higher than that of conventional loans. A lawyer who both bears the risk of not being paid and provides legal services is not receiving the fair market value of his work if he is paid only for the second of these functions. If he is paid no more, competent counsel will be reluctant to accept the word case from Ketchum. Turning to the question of compensation for fee-related litigation, we first note it is well established that plaintiffs and their attorneys may recover attorney's fees for fee-related matters. As we stated, the private attorney general doctrine will often be frustrated, sometimes nullified, if awards are diluted or dissipated by lengthy uncompensated proceedings to fix or defend a rightful fee claim. Serrano 4. While Daimler Chrysler does not dispute that fees for fee-related litigation may be awarded, it asks this court to hold that there should be no multiplier for fees on fees. It cites several out-of-state cases that have disallowed such multipliers, principally because fee litigation is tangential to the primary litigation and of less societal value. Courts awarding attorney's fees under 1021.5 may also generally differentiate between the contingency risk undertaken during the litigation on merits and the risk undertaken for litigation on fees. The risk that an attorney takes in the underlying public interest litigation has two components: the risk of not being a successful party, for example, of not prevailing on the merits, and the risk of not establishing eligibility for an attorney fee award. Serrano 3. Generally speaking, by the time of the commencement of fee litigation in Section 1021.5 cases, the first and perhaps most substantial component of risk, that of not being a successful party, has been eliminated. What remains is the second component, that plaintiffs may not be able to establish eligibility for fees, for example, to establish that that the litigation confers a significant benefit on the general public or a large class of persons from Beasley, or that there was the necessity of financial burden of private enforcement, making the award appropriate, from Hammond v. Agron, 2002. Although in the present case, as in other catalyst theory cases, plaintiffs had not established themselves as a successful party at the beginning of the fee litigation, and some enhancement for that risk may be justified, the achievement of their litigation objective before fee litigation would reduce somewhat the uncertainty over their successful party status. The fact that the risk of fee litigation is generally less than the risk of litigation on the merits of the suit justifies a lower attorney fee multiplier for the former. If one is given at all, we do not believe a lower multiplier on fees for less risky fee litigation deter attorneys from accepting worthwhile public interest cases. Disposition. The judgment of the Court of Appeal affirming the award of attorney's fees in the present case is reversed, and the cause is remanded for proceeding consistent with the views expressed in this opinion. And I'm going to stop the recording there.